appeal, the Queen on the application of Barkas and North Yorkshire County Council and another.
The ultimate issue on this appeal is whether Helredale playing field in Whitby, North Yorkshire, which is owned by Scarborough Borough Council, should be registered as a town or village green under Section 15 of the Commons Act 2006. The field was acquired in 1951 and has thereafter been maintained pursuant to Section 80, subsection 1 of the Housing Act 1936, now Section 12(1) of the Housing Act 1985, which empowers a local authority to, and I quote, provide and maintain recreation grounds. For at least the last 50 years, the field has been used by local inhabitants for recreation. In October 2007, the Helredale Neighbourhood Council applied to register the field as a town or village green under Section 15 of the 2006 Act. This provides that land may be so registered where inhabitants of the locality have, and I quote, indulged as of right in lawful sports and pastimes on the land for at least 20 years. A public inquiry concluded that although local inhabitants had used the field for this purpose for at least 20 years, their use had not been as of right. The application was accordingly rejected. On an appeal by Mrs Barkas, a member of the Neighbourhood Council, that rejection was upheld by the High Court and the Court of Appeal. Ms Barkas now appeals to this court. The Supreme Court unanimously dismisses the appeal for reasons in judgments given by Lord Carnworth and myself, with both of whom Lady Hale, Lord Clark and Lord Hughes agree. We consider that so long as land is held under a provision such as Section 12(1) of the 1985 Act, members of the public have a statutory right to use the land for recreational purposes, and therefore the use of the land is by right rather than as of right. If a person uses land by right or of right, the use is rightful because it's been permitted by the landowner. However, a number of cases relating to the acquisition of rights over land by prescription, that is, by long use, establish that such use has to be without the permission of the landowner, but must be carried on as if it were by right. Hence it's described, as in the statute, as of right. The significance of the tiny word as is therefore crucial, making the expression as of right effectively the antithesis of by right. The general rule is that use is as of right if it is, and I quote, not by force, nor stealth, and nor license of the owner. And this normally applies to town and village greens under the 2006 Act. So long as land is held by a public authority under a provision such as Section 12(1) of the 1985 Act, members of the public have a statutory right to use the land for recreational purposes. Therefore, their use is by right and not as trespassers, so it cannot be as of right. The position is very different from that of a private owner with no legal duty and no statutory power to allocate land for public use and with no ability to allocate land as a village green. The decision 10 years ago in Beresford and Sunderland City Council, where the House of Lords held that the public's use for more than 20 years of land maintained by the local authority was as of right, should no longer be relied on. It's clear on the facts in that case that the City Council and its predecessors had lawfully allocated the land for the purposes of public recreation for an indefinite period, and that in those circumstances there was no basis upon which it could be said that the public use of the land in that case was as of right rather than by right.